At the end of the last episode, I told you the next story ends the argument forever. The argument that you need a law firm, or a lawyer, or a single dollar to force this system to listen. So let me introduce you to the man who ended it by listing everything he had. He was 51 years old. He had an 8th grade education, 4 felony convictions, no money, no property, no family waiting for him, and a medical file that read like a warning label. His current address was a cell in the Florida State Prison at Raiford. His job title, on the rare occasions he had one, was drifter. And in January of 1962, this man took a pencil, a stack of lined prison paper, and a rule book he had taught himself to read in the prison library, and he wrote a 5-page letter to the Supreme Court of the United States. The spelling was shaky, the grammar limped. The legal citations were the kind you'd expect from a man whose law school was a shelf next to the laundry room. And here is the paradox this entire video is built on. The Supreme Court of the United States receives thousands of letters like that. Desperate, handwritten, hopeless petitions from prison cells all over the country, and nearly every single one of them dies in the mailroom, unread by any justice, because that is what those letters do. They die. This one did not. The most selective court on planet Earth, the court that turns away governors, senators, and billion-dollar corporations without comment, reached into that mountain of doomed mail and picked out the pencil letter from prisoner number 003826. It heard his case, and on a Monday in March 1963, all 9 justices unanimously used that drifter's letter to rewrite the constitutional machinery of every courtroom in America. His name was Clarence Earl Gideon. He was nobody, and that was exactly the point. By the end of this video, you will understand 3 things. First, how a misspelled petition from a prison cell beat odds of thousands to 1, and why that was not luck. It was leverage, the 4th and final weapon in the stack this channel has been mapping since episode 1. Second, why the state of Florida's easiest win, convicting a broke drifter with no lawyer in under a day, quietly became the most expensive courtroom victory in the history of American prosecution. And third, what happened when the exact same man was tried twice for the exact same crime, in the exact same courtroom, once alone and once with a lawyer, because that is the closest thing to a controlled science experiment the American justice system has ever accidentally run on itself. And the result should keep you up at night. I'm Lenny. This is Lawful Lenny, and on this channel, we don't chase the verdicts. We map the leverage behind them. Start with the crime, because the crime is almost insultingly small. Panama City, Florida, June 3rd, 1961. Sometime between midnight and 8 in the morning, somebody broke into the Bay Harbor pool room, a beer and billiards joint in a scruffy waterfront neighborhood. The burglar smashed a window, cracked open the cigarette machine and the jukebox, and made off with a modest haul of coins, some beer, and some wine. That's it. That's the entire crime. No masterminds, no vaults, no diamonds. A vending machine's lunch money. In 2026, this crime gets solved before breakfast. There's a doorbell camera across the street. The pool room has an app that pinged the owner's phone at the exact moment the window broke. And by noon, some subreddit has enhanced the footage, identified the burglar's sneakers, and found his high school yearbook. In 1961, the entire investigation was one question. Did anybody see anything? And one man said yes. A 22-year-old named Henry Cook told police he'd been outside the pool room at 5:30 in the morning, as one does, and saw Clarence Gideon inside. Gideon was a regular there. He was known to the police, he had a record, and when they found him later that morning, his pockets were heavy with coins. That was the case. One young witness with excellent reasons to be somewhere else, and a poor man carrying change. On that, Florida charged Gideon with breaking and entering with intent to commit petty larceny, a felony. And you should be asking the question Gideon asked. Fine, where's my lawyer? Because here is what happened in that courtroom on August 4th, 1961, and I want you to hear it plainly. Clarence Gideon stood up in front of Judge Robert McCrary and asked the court to appoint him a lawyer because he was too poor to hire one. And the judge said no, not because he was cruel, because that was the law. Under Florida law, a poor defendant got a free lawyer only in capital cases. If the state could kill you, you got counsel. If the state could merely take 5 years of your life, you were on your own. Good luck, jury's waiting. And Gideon, standing there in a courtroom with his life on the table, said something remarkable. He said, "The United States Supreme Court says I am entitled to be represented by counsel." Now here's the uncomfortable part. He was wrong. At that moment, in 1961, the Supreme Court said no such thing. 20 years earlier, in a case called Betts against Brady, the court had ruled that states did not have to give poor defendants lawyers in ordinary criminal trials. Only in special circumstances, if you were illiterate, or very young, or mentally disabled, or the case was unusually complicated, then maybe. A grown man of average intelligence accused of burgling a pool room. Handle it yourself. So Clarence Gideon, 8th grade education, defended himself in a felony trial. And look, in 2026, the average person rehearses before calling a restaurant. We draft text messages and delete them. There are people who need 3 business days to reply to an email that says thanks. This man had to perform an entire jury trial, live, solo, against a trained prosecutor. He gave an opening statement. He cross-examined Henry Cook, badly, without knowing which questions matter. He called witnesses who didn't help. He made an argument for his innocence that touched none of the legal points that could have saved him. He did, by all accounts, about as well as any untrained man could do, which is to say, he never had a chance. The jury convicted him in short order, and Judge McCrary gave him the maximum, 5 years, for a jukebox and a cigarette machine. Total elapsed time, less than 1 day of court. Florida had just won the easiest case on its docket. Remember that sentence, because the invoice for that easy win is coming, and it is still being paid today. So Gideon went to Raiford, the state prison. And this is where the story stops being about a burglary and starts being about the machine. Because Clarence Gideon, a man whose life had been one long losing streak, did not accept the loss. He went to the prison library and started reading law, slowly, painfully. A man with an 8th grade education, working through case reporters and procedure manuals between shifts and lockdowns. He filed a habeas corpus petition with the Florida Supreme Court, arguing his trial was unconstitutional because he'd been denied counsel. Florida's highest court denied him without ceremony. And for roughly 100% of prisoners in his position, that is where the story ends. But Gideon had read enough to know there was one door left, the longest of long shots, a procedure called a petition for a writ of certiorari, asking the Supreme Court of the United States to take your case. And because he was broke, he filed it in forma pauperis, in the manner of a pauper, which waives the fees and the fancy printing requirements, just paper and honesty. So in January 1962, he sat in his cell and wrote it out in pencil, in careful, cramped schoolboy handwriting on lined prison correspondence paper, under the stamp of the prison mailroom censor. 5 pages arguing that the state of Florida had tried and convicted him without a lawyer, and that this violated the Constitution of the United States. Sit with the scale of that for a second. In 2026, we ask an AI to punch up a 2-sentence email. We have apps that write our birthday messages, and the signature feature does the rest. This man, from a prison cell, with a pencil, hand-built a formal petition to the most powerful court on earth, from memory and a borrowed law book. And then he mailed it into a pile of 2,000 other petitions just like it, of which the court, in a typical year, grants almost none. It was, statistically, the single worst bet in American law, sliding into the Supreme Court's DMs, certified mail edition. And the Supreme Court said yes. Now, why? Because this is the part of the story everyone gets wrong, and it's the part this channel exists for. The fairy tale version says the justices were so moved by the little guy's letter that they took his case. No, courts do not run on being moved. Here is what actually happened. For 20 years, the Supreme Court had hated its own rule. That Betts decision from 1942, the special circumstances rule, had produced 2 decades of chaos, with state courts guessing at what counted as special, and case after case crawling up on appeal, and the court itself carving exception after exception until the rule was mostly holes. Several of the justices had been openly signaling, in written opinions, that Betts was ripe for burial. What the court needed was a vehicle, the right case, with the right clean facts, at the right time. A defendant who was ordinary, no special circumstances to hide behind. A small, honest crime. A clear denial of counsel, stated plainly on the record. Gideon's pencil petition wasn't a lottery ticket. It was a key sliding into a lock that 9 justices had already decided to open. That is the 4th weapon in the stack. In episode 1, I gave you discovery, contingency, and the jury. The 4th is precedent, and here is how I need you to understand it. In this system, the rules themselves are on trial, permanently. Every case is secretly 2 cases, the defendants and the rules. And when the machine has decided a rule needs to die, the most powerful thing in the entire building is not money, and it is not an army of litigators. It is being the right nobody, in the right cell, with the right facts, at the exact moment the machine goes looking for an excuse. Corporations pay 8-figure legal bills trying to manufacture that alignment document on purpose. Gideon assembled it, by accident, out of a jukebox, a pool room, and a pencil. And then the machine did something that tells you it meant business. The Supreme Court appointed Gideon a lawyer. And not just any lawyer. They gave him Abe Fortas. Understand who that is. Fortas was a founding partner of Arnold Fortas & Porter, one of the most powerful law firms in Washington. A man whose regular clients were corporations and whose regular fee could refinance your house. A man who would himself sit on the Supreme Court within 3 years. The drifter who couldn't afford a Panama City attorney was now represented, for free, by a future Supreme Court justice who threw his firm's full war room at the case. Briefs, associates, months of preparation, all of it unpaid. And then it got stranger. 22 states filed briefs in the case. And here's the twist. They filed them against Florida. 22 state governments, led by a young Minnesota Attorney General named Walter Mondale, formally told the Supreme Court, "Please rule against the states. We want to be required to give poor defendants lawyers." Imagine being ratioed so hard that half the country files formal paperwork agreeing you should lose. Poor Florida sent a 26-year-old assistant attorney general named Bruce Jacob to defend the old rule. A junior lawyer ordered to hold a collapsing wall, alone, in front of 9 justices who had already picked out the wrecking ball. On January 15, 1963, Fortas stood up in the marble courtroom and made the argument simple. You cannot have a fair adversary system where one side is a trained professional and the other side is a scared amateur. A criminal trial is not a fair fight without counsel. It is a ritual with a predetermined ending. 2 months later, on March 18, 1963, the court ruled 9-0, unanimous. And the justice chosen to write the opinion was Hugo Black, the same Hugo Black who had dissented in Betts in 1942, who had spent 21 years watching his warning come true, and who now got to stand at the graveside of the rule that outvoted him and read it into the ground. "In our adversary system of criminal justice," he wrote, "any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. Lawyers in criminal courts," said the court, "are necessities, not luxuries." With those words, the right to counsel stopped being a federal courtesy and became a national command. Every state, every felony courtroom, every poor defendant. Because a drifter with a pencil asked. Now here is where it gets really interesting, because for Clarence Gideon personally, winning at the Supreme Court won him precisely nothing. The ruling didn't free him, it just erased his first trial and sent him back to Panama City to be tried again. Same charge, same courtroom, same judge. And this is where the story becomes that controlled experiment I promised you. Same defendant, same crime, same evidence, same witness. One variable changed. This time, Gideon had a lawyer, and I love this detail because it tells you everything about the man. When the celebrated legal organizations showed up to represent the now famous Gideon, he turned them away. He wanted a local. He asked for W. Fred Turner, a Panama City trial lawyer who knew the town, knew the pool room, and knew the people in it. And Turner did what lawyers actually do. The unglamorous thing this whole channel keeps pointing at. He did the homework. He investigated the state's one and only witness. And at the retrial, in August 1963, Turner took Henry Cook apart on cross-examination. Why exactly was a 22-year-old standing outside a pool room at 5:30 in the morning? What was his record? Who were his friends? And then Turner offered the jury a simple alternative story. That Cook wasn't a bystander at all. That he and his crowd were far better candidates for that burglary than the older man he pointed at, and that pointing at Gideon was a very convenient way to change the subject. The prosecution's case, which had sailed through unopposed in 1961, fell apart in an afternoon of competent lawyering. The jury deliberated for about an hour and came back with 2 words Florida had refused to spend a lawyer's fee to risk hearing: not guilty. Same man, same facts, same room. With a lawyer, innocent. Without one, 5 years. That is not a story about one burglary in Florida. That is a measurement. It is the clearest reading anyone has ever taken of exactly how much justice in an American courtroom depends not on what you did, but on who is standing next to you when you say you didn't. And the invoice came due immediately. Because the ruling wasn't just about Gideon, Florida's prisons were full of people convicted exactly the way he had been, tried without counsel, and the state now had to deal with all of them. Thousands of prisoners were released outright. Thousands more got new trials with lawyers this time. And nationwide, the decision forced into existence the entire modern machinery of the public defender, an army of state-funded lawyers that had to be invented, funded, and staffed in every county in America because of a 5-page pencil letter. Run this channel's cost cost ratio one more time because it will never be this lopsided again. The state of Florida saved itself one court-appointed attorney's fee in 1961 in a town where a lawyer like Fred Turner could have handled the whole thing for a modest check. In exchange, it bought 2 trips through its own court system, a Supreme Court defeat with its name on it forever, the release of thousands of convicts, and a permanent, nationwide, billion-dollar-a-year legal obligation binding all 50 states until the end of the Republic. That is the worst trade in the history of American government accounting, and somewhere in there is the lesson this channel keeps finding under every rock. The giant never pays less by denying the little guy his rights. It just converts a small bill today into a monstrous one later, with interest compounding in the dark. Anthony Lewis wrote the book on the case, Gideon's Trumpet, and Hollywood eventually came for it too, with Henry Fonda playing the drifter. The comment war under this one splits clean, and I want both camps on record. One camp says the system worked. It caught its own error, corrected itself unanimously, and handed a penniless man the full might of the Constitution, proof the machine self-repairs. The other camp says the system got caught. It convicted an innocent man in an afternoon. It only listened because his letter happened to fit the court's agenda, and for every Gideon whose pencil found the lock, thousands of letters died in that mailroom unread. So which is it? The machine worked or the machine got caught? One phrase in the comments. And to the justice and jackpot camp still brawling under the Brockovich episode, a viewer named Denise, yes, the same Denise, put it this way: the right answer to a broken system is apparently to be the exact kind of broken it's embarrassed about. Half of you are going to love that. Half of you are going to report it. Round 5. I am reading every reply. One last thing. Because this channel deals in the public record, and the record does not do fairy tales, start with the man. Clarence Gideon did not become rich, or polished, or redeemed in the Hollywood sense. He stayed poor. He kept drifting. He died in 1972, at 61, and was buried in an unmarked grave in Hannibal, Missouri. It took years before anyone gave him a headstone, and the line they carved on it comes from a letter he wrote to Abe Fortas. Each era finds an improvement in law for the benefit of mankind. A man the system valued at 0, correctly predicting his own monument. And now look at the improvement itself, because this is the part they don't put in the movie. The right Gideon won is real, and it is everywhere, and it is starving. The public defender systems his case created are, in much of the country, catastrophically overloaded. There are defenders carrying hundreds of cases at once, meeting clients for minutes in a hallway before deciding the direction of their lives. The overwhelming majority of criminal cases in America now never see a trial at all. They end in plea bargains, justice at the speed of a drive-through. Take the deal. Sign here. Next window, please. In 2026, you will wait longer on hold with your bank than some defendants get with the lawyer Gideon's case guarantees them. We built the right. We never fully paid for it. And a right without funding is a promise the system makes with its fingers crossed. So when you ask whether Gideon won, the honest answer is, he won the argument. The argument was the easy part. The Republic has spent 60 years negotiating the invoice. So here is the question this whole video has been building toward. The most powerful court on earth needed a nobody. Not wanted, needed. All the marble, all the robes, all the precedent in the reporters. And the machine could not fix its own broken rule until a 4-time felon with a pencil handed it the excuse. So which is the real Constitution? The one in the display case in Washington, under glass and armed guard? Or the one that has to be re-earned, case by case, by whichever unqualified, unlucky, stubborn nobody refuses to accept the loss? Right where you stand, I am reading. This is Lawful Lenny. We don't chase the verdicts. We map the leverage behind them. And if you think the little guy at least needs the law on his side to survive the giant, the next story is for you. A burger empire worth billions sued a part-time gardener and an unemployed postman over a stack of photocopied leaflets. No legal aid, no lawyers. 2 broke activists defending themselves against the most famous corporation on the planet in what became the longest trial in English history. The giant spent millions, technically won, and walked away from the wreckage begging them to stop. They said no. That is the next video. Watch it next. I'll see you in the court.